So yeah, we're going to have a romp through rights and privacy issues. I am going to activate my screen. So I'm just going to make sure that the guys have set that up for me, and then we will be good to go. I've got about 40 minutes of content for you, and then about 10 minutes of questions. So let's get going. Okay. Here we go. All right, so it's a pleasure to join you today, and it's been an amazing year that we've had together, creating loads of resources as part of the Heritage Digital stream of work funded by the National Lottery Heritage Fund. I will be showcasing some of those resources as I go through the presentation today. So it's about collecting digital stories, and we're going to be exploring the rich world of rights and privacy issues. I've had a really long think about how to put this presentation together for you, and I'm following a kind of a sequence, and I've tried to break it down for you into manageable chunks. My presentation and content within it will be available for you subsequent to this session. So if you've missed anything, you can refresh your memories. The copyright with regards to this presentation is that it's available for you to reuse under a Creative Commons attribution license, which means that you are free to reuse and share and adapt and change. All that we require is crediting. Now, whilst the team at Nomicon Associates is pretty small, there are 3 of us at the moment, myself, Patrick and Maddie, being part of this consortium has enabled us to be involved in the most incredible projects. So putting all that together, I'm going to be talking about the legal and ethical context of collecting. We're going to be looking at some of the key ownership issues, picking up on work that we've done previously for this project on volunteers and contractors and staff. We're going to be looking at key issues relating to collecting content from social media. We're also going to be examining the copyright exceptions, and some of you may be familiar already with the guide to the exceptions to copyright that we've just released through this project. And we're also going to be talking about funding requirements and how that might change what you do and what you collect. So a few things just to start our journey. I just wanted to remind ourselves about what our role is, whether we are museums or libraries or galleries or archives, or small collections based in other organisations, whatever your shape or form. Many of our reasons for being is to collect, whether it's the present of today that becomes history tomorrow, or to collect the past. Our role is as the people that are the custodians to the history of tomorrow. And it's not just about collecting this information. For many of us, and hot-wired into our strategic objectives is the very act of making it accessible, whether that is in person when people come to visit our premises. And I think certainly during COVID, those of us who have been able to provide access to collections through our online facilities and platforms, through our websites and other platforms, I think have become more cognizant now about the necessity of digital skills to ensure that we have got those items, those precious items available digitally when our premises may be shut. I also wanted to reflect a little bit on what we mean by digital stories, because what we mean by digital stories can also have an impact on some of the rights and privacy and ethical issues. And so, yes, many digital stories relate to conversations or narrations of things that are happening today. But we also have to remember that many of us will have rich collections of analog-based stories on, whether it's on videotapes or even cassette tapes, that are digital stories. And so digital stories of today may be digital copies of existing stories we have. They may be digital copies of stories that others have told, but we also may be collecting from social media, from YouTube, from Twitter, as Andrew showed us. I also wanted to remind you that digital stories can take various forms. They can be perhaps photographs, and I've captured here a couple of photographs taken from the Stop the Brexit March, and also a march in Washington taken in 1963. So the marches of today, whether it's also the anti-COVID protests or any current activities, are the stories that we are collecting, form part of our contemporary collecting policies. We should also be cognizant of projects that are collecting digital stories, such as the British Library's Save Our Sounds projects. And I also wanted to give you a couple of examples of stories that may be collected through blog posts. And these are a couple that we've, a recent story that I wrote, or indeed our tweet streams. And the very action of the Twitter stream that's being created today, talking about this very conference, is a digital story. And we're capturing today what is the history and part of our important collections of tomorrow. But I also wanted to take another, perhaps more expansive view about digital stories, and I think bring to the fore the very action and the very act of creating artworks themselves can be digital stories too. And one of my favorite artworks, and really this is, I guess, the focus of my presentation today, is Christian Marclay's The Clock. Now, this is a fantastic artwork that is 24 hours long, watching time unfold in different films. So if you're not familiar with it, Christian Marclay has taken snapshots of moments in films that display or talk about time, and through that created a 24-hour clock. It is mesmeric to watch it. And I remember a happy couple of hours I stood at the Whitechapel watching The Clock. Now, the reason why I've selected The Clock particularly is not just because I love it, it's also because back in the early 2000s, I was working at the Tate as their copyright officer, and the Tate was considering acquiring an edition of Christian Marclay's The Clock for its collection. And when I was putting the slides together for you today, I wanted to give you a real example of some of the challenges relating to legalities, whether they are copyright, privacy or others, and some of the ethical issues, and also based it upon a journey that I had in trying to ascertain indeed whether the Tate should even acquire the work or not. So what I've done for you is put together, if you like, a script of the considerations that we took into account at the Tate when we were thinking about acquiring The Clock. Now, this works really well for any type of digital story, whether it's one that exists now, or indeed a digital capture of an existing story you have, or even a digital story within an artwork. So my first kind of starting point is to understand, what are you collecting and for what purpose? Now, is it a photograph? Is it a sound recording that you're making? Is it something that you have in your collection already? Because by understanding this, you can already start to unpick the rights issues that might be associated with it. Now, a dimension to the purpose and thinking about kind of what it is actually thinking about some of the points that Andrew was raising earlier. So if you're scooping this content up from social media platforms, it's about understanding what platform you're collecting from, understanding the use to which you can make the content you find on the social media platforms. And this is interesting because looking at the terms and conditions of many of the social platforms that we use habitually, whether they are, whether it's YouTube or Facebook or Twitter, many of them restrict subsequent use to non-commercial personal use. And indeed, YouTube is an excellent example of this. Now, social media platforms have become part of the air that we breathe, but indeed they actually have fairly restrictive uses with regards to what you can subsequently do with that content. And from a museum perspective, a cultural heritage perspective, it's important that we're aware of that. Legal compliance issues don't go away if we're dealing with digital content, and indeed, even very recent case law and recent examples clearly demonstrate that people's use of social media and reuse of social media or content they find on social media does not provide them with a blanket coverage against subsequent legal action if necessary. And I'll be unpicking some of the issues regarding social media as we go through our journey today. The second aspect to understanding the purpose and what it is you're collecting is to understand the relationship that you may have with anyone that's facilitating that collection of the content or creation of the content. And here I've wanted to flag up to you in particular the nuances and issues associated with potential funding terms and conditions, with particular reference to the National Lottery Heritage Fund. Now, since October of last year, the National Lottery Heritage Fund changed its terms and conditions of funding, which means that any content that you make available as a result of receiving funding from them needs to be made available itself under a Creative Commons attribution license. And that's really important because the benefits of making content available under a Creative Commons attribution license are profound. It means that anyone in the world, it doesn't matter who they are, can use that content for whatever purpose they want, only with an attribution requirement. Now, whilst the benefits are profound, it's also very important that we understand what the legal issues are associated with making content that accessible. And this is really the next part of the journey that we're going to be having together. So, in order to understand the legal obligations that you may have, it's important to understand who has created the asset that you're wanting to use to collect, the digital story that you are intending to feature as part of your collection items. And a number of stakeholders. It might be a digital story that's been created by a member of staff. It might be a digital story that's been made by a volunteer, perhaps by somebody that's donated something to you. It could have been made by an artist or a supplier. Maybe a digital story has been created by a contractor. It could have been made by a member of the public. It could have been made by someone else. So establishing who has created that digital story starts again to illuminate in more detail the rights issues that we need to be thinking about, which I'll be covering in a moment. I should also add too that in many cases, digital stories may not have just one creator. There may be multiple. A good example would be a recording where there is both an interviewer and an interviewee. Even more than that, sometimes we have digital stories where there's an interviewer, an interviewee, and each of them or one of them may themselves be repeating content that someone else has created. This rich and sort of multifaceted aspect to digital stories can, of course, provide huge value to our collections, but at the same time needs to be unpicked for us to understand the rights and privacy issues that may be associated with it. So here we go. The everything you ever wanted to know about who's created your digital stories. Good news is that if it's a member of staff, so someone who is an employee of your organisation, the copyright, and this is as outlined in the copyright legislation, will be owned by the employer. Now, the employer could be the board of trustees, it could be a parent body of your organisation, but the bottom line is that anything that's created by staff as part of their work for your organisation will be owned by your organisation. But then thereafter, the situation gets more complicated. Anything that's made by volunteers, the first owner of copyright will be your volunteers. Anything made by donors, actually, the copyright may not be owned by them at all. It may be by the creator of what they're donating. So, for example, a letter perhaps that's been donated to your organisation that itself is a digital story, the copyright in that will not necessarily be the donor's copyright, but actually the person who wrote the letter. The donor may well be the recipient of the letter or related to someone who received the letter, but the copyright will actually, in the first place, be owned by the person or the next of kin of the person who wrote the letter. Anything created by an artist, generally speaking, the first owner of that work will be the creator themselves. A supplier, the first owner will be the supplier or the creator, and anything created by a member of the public, even if it's from a social media platform, will be owned by the creator, will be owned by the person who uploaded that content and had the rights, or indeed there may be, again, a multitude of rights associated with that content, whereby there could be rights owned by the owner of the first person who uploaded the content onto that platform, but also subsequent, perhaps, layers of rights in that content may be owned by third parties as well. So what do we need to move forward in order to be able to collect these items, preserve them, and potentially use them? Well, perhaps the first point of contact for digital stories is working towards securing the consents and rights. With regards to copyright, as I said, because copyright is owned by an employer, so it could be, again, a photograph taken by a member of staff. It could be perhaps their input as an interviewer. The requirement will not be to clear rights because your organisation will own it, but there will be a necessity to seek authorisation from some of the other stakeholders that are listed here. Now here I can start signposting to resources that we've already created. When dealing with suppliers, the first owner, as I said, is the contractor themselves. The guide that we have created as part of this project provides you with a comprehensive oversight to dealing with those rights issues, understanding the necessity to seek either an assignment of copyright or indeed a license. Similarly, when dealing with volunteers, as I said, the first owner of copyright may be the volunteers, even if they're doing something for your organisation. And of course, there is an additional complexity, I know, for many cultural heritage organisations, which is that volunteer-run organisations need to understand their governance and need to understand perhaps the broader issues to ascertain the ownership of rights and to make sure that there are the necessary arrangements in place for dealing with copyright. And again, there's a set of resources that I would strongly recommend that you have a look at subsequent to today's presentation for you to unpick these issues. So what else should you consider once you've dealt with the copyrights in the contents from the multitude of perspectives that I've given you? It's also being aware that there may be third-party rights where permission will need to be sought, but also, and crucially, other rights issues, which include data protection and privacy. Please don't forget that identifiable individuals, living identifiable individuals, have rights of privacy over any personal data, and personal data can include their names, their addresses, their very images. And this is where individual consent becomes important. There is also an overlap for digital stories, perhaps that are more based on images of people or recordings of people, to understand a correlator intellectual property right, which is performers' rights. If you are making recordings of people, you need to seek consent, and this should be in writing, not just to record them, but then to subsequently use those recordings. Now, if you're clever and you're dealing with perhaps data protection, copyright and performance rights, there is a way of incorporating permissions for all three if it's from the same person in one form, in one document. Now, in my experience, copyright and privacy issues can be dealt with in an upfront and straightforward way, ideally prior to digital stories being created. And it's about building rights and privacy into the very heart of your organisation and what it does in its collecting policies. However, if you have a legacy of content, perhaps that you've already collected, that already forms part of your collections, or indeed you're scooping up and scraping digital stories that other people have collected, this may not be straightforward. And so dealing with copyright at the point of acquisition, many of you will be aware of Spectrum and the necessity of dealing with copyright as part of the acquisition process may not be relevant in this case. And so building into your organisation's processes, perhaps retrospective rights clearance, then becomes a way of dealing with these issues, ensuring that you do follow protocols, you do recognise that you can't just collect something and not do something with the rights issues, particularly if you want to use these items downstream. I'm also very cognizant too that there are often other legal issues that you may come across that need to be dealt with also. Perhaps you are collecting digital stories that include particular points of view about living people, and that may cross the line into libel and defamation. Good news is you can't libel the dead. Always good to know these things, but at the same time, this still needs to be built into your strategy. So, some of the ways of resolving these issues. We've done a lot of work on this for the programme of work as part of the Heritage Digital Consortium. We have produced a guide to the exceptions to copyright recently. I'll give you a link to that in a moment. But I guess when I was putting together this presentation, I wanted to think about the 3 key issues I wanted you to take away with regards to using the exceptions to copyright. And to refresh your knowledge, the exceptions to copyright are hotwired into the legislation. They provide a means for organisations like ourselves to use certain types of copyright works in certain contexts without having to clear copyright. Now, within the context of digital stories, I would say that there are 3 different dimensions to consider with regards to the applicability of exceptions to copyright to digital stories. First of all, thinking about what you're collecting, whether you can use them in that context and whether they have any place to play. Second of all, to think about whether we can use exceptions to copyright to justify our preservation of digital stories. And third of all, to consider the use of the exceptions to copyright to think about whether they can help us use digital stories. Now, of course, there are many different issues associated with digital stories, rights and privacy issues. This is a snapshot, and this is as a sort of picking up on perhaps some of the key themes to help you start your journey. So more about the exceptions to copyright can be found here. Here's a link to the guide that we wrote very recently. And again, together with the guide to contractors and the guide to working volunteers, please do have a look at the guides following this presentation. But as a summary, I wanted to look at some of the key exceptions to copyright, which I think will probably be of greatest value to you. The first is the criticism, review and quotation. Now, it means that we can legitimately use excerpts or extracts or sections of copyright works within certain contexts to illustrate certain points. It doesn't mean that we can just use a work as a kind of, this is an example of a sort of, I guess, maybe adding a bit of colour to our exhibitions or to our website activities, but more about a direct reference to what we are illustrating, what we're showing. So the quotation exception is important. It can be used within an exhibition context. It could be potentially used within a print context and also within presentations. We've done a lot of thinking about this and talking to other colleagues, and I think that the views from experts is that there is an increasing potential use of the quotation exception in an online basis, but we have to be absolutely clear that the extract of the copyright work that we're using, and this is without having to clear rights, is fully justifiable. That particular extract exemplifies a specific point that we're making, so that becomes important. Okay, other exceptions to copyright that we might find useful. One is the non-commercial research and private study exception. It enables us to make copies or a singular copy of a copyright work for our own personal use. It might enable perhaps digital stories to be collected by individuals in the first place for their personal use. So the very action of collecting an item could be legitimised by this particular exception. Subsequent use, however, particularly from an organisational perspective, would need to be justified by one of the other exceptions that I'm going to be taking you through. Current use reporting enables press and media to use images of copyright works where there is a particular story associated with them. And this is a challenge for us as cultural heritage organisations, because even though they may be using images of copyright works, perhaps to illustrate a particular story, the newsworthiness of continuing to use that image, that copyright work, beyond the lifespan of the longevity of the story itself, which may only be about 24 hours, may be limited. So yes, it may exist, but our subsequent preservation and subsequent use of that copyright work may be needed to be seen through the lens of either other exceptions to copyright or perhaps licenses and getting permission to reuse. Illustration for instruction purposes would enable us to show digital stories as part of our broader educative activities, particularly on site. We could take a copyright work, again without clearing the rights, and use it perhaps as a way of illustrating a particular event, historic event or activity that we have been involved in, or a project, to a group of people. How far that translates to the web and using it in a web-based context becomes more problematic. There is more information in the guide about the way in which the exceptions to copyright work on an international basis. Parody, caricature and pastiche is a new exception. We've had this in our legal framework since 2014. It does enable the creation of digital stories, perhaps that might use content that parodies other types of perhaps or pre-existing pieces of work. We've given you an example here of a placard from one of the demonstrations against Donald Trump, which is Humanity Against Trump. And we thought that that was a parody on Cards Against Humanity, the popular card game. Now, again, whilst it would enable us to perhaps as collecting organisations maybe anticipate less risk from collecting the item, our subsequent use of that item, i.e. reproduction on our websites, or maybe making other reproduction items from that core collection work, may require either the use of another exception to copyright or indeed getting permission. We need some legal basis for dealing with the copyright. But there is good news in the exceptions to copyright. We have an exception that enables us to take our collection items and create a digital copy of these collection items and put them on a dedicated terminal, like a computer screen. It can only be used right now for on-site visits, but it means if we are collecting digital stories, perhaps that form part of our collections, are accessioned into our collections, we can then display those digital stories on perhaps terminals or even handheld devices for members of the public to be able to engage with them. And this exception goes hand in hand with the preservation exception. We can take and we can make preservation copies of works in our collections legally under the Copyright Designs and Patents Act. It doesn't mean that we can subsequently use those preservation copies unless there is either another exception to copyright that we can justify, or indeed we get permission. And then a couple more to whet your appetite if it hasn't been done so already. Incidental inclusion. The law enables us to collect, to make perhaps digital stories and include within them other copyright works if those other copyright works are incidental or perhaps unrelated to the key activity. And we've given you some examples here of perhaps uses of the incidental inclusion exception. And then the freedom of panorama exception enables us to create digital stories that might include sculptures or artworks permanently located in premises open to the public. I've given you an example of the sculpture of Millicent Forsyth by Gillian Waring, which is available in Trafalgar Square. It's available in Parliament Square, and is a really extremely useful example for us to remember that digital stories, again, can comprise of lots of different elements, but there is some sort of carve-out, useful carve-out in the legislation that does enable us to use copyright works in certain ways without getting permission. Now, of course, there may be circumstances in which you come across works that are in copyright where you cannot trace the rights holders, and these are called orphan works. Generally speaking, any kind of rights management by cultural heritage organisations will require some degree of risk management. Now, this will be in conjunction with orphan works, or indeed it could be in conjunction with the very use of the exceptions to copyright, which I spoke about earlier. And if you, again, would like to refer to the guide, you'll see that I talk a lot about the use of the exceptions to copyright being defences rather than rights. Now, ways to deal with orphan works include a very risk-averse position, which is not to use them, or you can have more, I guess, of a risk-aware approach, which would enable you to accept a degree of risk and think about the items that you're collecting, but at the same time build into your organisation's procedures risk mitigation activities. And this could include recording the risk on a risk register, evaluating how you deal with thinking about the levels of risk that might be associated with the work, building into your documentation how you've gone about to try and trace rights holders. Clearly having a notice and takedown policy and procedure becomes fundamental to making sure that you can deal with something if it goes wrong. And that could be considered hand in hand with a disclaimer. When collecting digital stories, think about how you're then going to make the digital stories available. We think perhaps that platforms just include our websites, but increasingly we need to think about other platforms such as social media platforms, thinking about even recording platforms such as these, and thinking about also other websites that we may be putting our content on, for example, Europeana or Google Arts and Culture. Like the social media points I raised earlier, the platforms that we use as subject to the terms and conditions are the platforms upon which we put our content. And specifically, we have to remind ourselves that, like the terms and conditions perhaps that we are subject to with regards to where the sources of our funding comes from that I mentioned earlier, the places upon which our digital stories appear present contractually binding arrangements. We have responsibility for dealing with the legalities of the posting of the content. We have to make sure that we have the rights in the content that we can post. And this is why I looked at who's creating the digital stories and dealing with that first, to ensure that we recognize that if someone else has created digital stories that we wish to post on social media platforms, we have not just a responsibility for posting something where we legally have the rights, but also we carry the risk. We also should be aware too that posting on social media platforms and the agreement to the terms and conditions by the very fact of uploading and downloading content means that we also grant a very extensive reuse license of the content that we're posting on those platforms for the social media platforms themselves to be able to use, and anyone else that they so wish to grant that license. So again, going back to some of the points I raised earlier, whether it's rights or privacy issues, we need to be making sure that we have enough consents and rights to enable us to post that content on social media platforms. It also is worth raising that wholly relying on the exceptions to copyright and then posting content subsequently that you've relied on, whether it's to collect or to keep or to use the content under the exceptions to copyright, will not go far enough in giving you the rights that you need to repost that content on, which is why today is about a hybrid of both rights, permissions, and exceptions. So I've got a couple of minutes, I know, left. And so I really just wanted to make, if you like, the killer points at the end, right? I'm going to reward you for listening to me and taking on board what I've been saying. Collecting policies. So the seventh aspect to this is thinking about what you're doing, why you're doing that, and thinking about the role of your organization and what other people have done. And when we were thinking about the Christian Marclay clock, acquiring this for the Tate, one of the really big questions was, well, the Tate wasn't alone in buying an edition of that work. What did other organizations, whether it's the Met or some of our European colleagues, have done with the clock? And actually, many of them had acquired that work, even though the rights hadn't been cleared in the clips, and were able to use that as part of their risk evaluation to think about what happened to those organizations. And at that point, nothing had happened to the organizations with regards to acquiring work that itself contained other rights issues. So what I'm saying is sometimes the digital stories that we collect, whether it's because it's third-party rights that we can't identify, whether it's because the exceptions that we can't quite use, whether it's because they contain orphan words, the rights issues may not ever quite be resolved. And so the role of risk management becomes important. And then going back to what I said earlier, evaluating what is our purpose as collecting bodies and trying to think about managing that together with perhaps unresolved rights issues. And here I wanted to give you an example of that in place. So I've concentrated today on the things that you can do, but also really I wanted to almost end today by saying that this is the ideal. In many situations, we can't actually resolve the rights issues. And so this is a lovely example of a letter that was written by David Graeber, who was 19 years old. He lived in the Warsaw Ghetto, and him and a number of other of the occupants of the Warsaw Ghetto buried a number of their memories in a time capsule under the ground, which was discovered fairly recently. So this is Holocaust material, and we've traditionally felt very uncomfortable, I think, about collecting more contentious material. But here he actually says that what he wants from the content that was buried in the time capsule was that it's actually made available to the public. It's his voice and the voices of those that were living in the Warsaw Ghetto. And so I think that this is a really kind of good place for me to effectively kind of scoop up everything I've said so far to you, which is that the ethical issues of collecting, whilst we, I think, traditionally are fairly risk averse and think about maybe taking a more cautionary approach to collecting digital stories like Holocaust material, actually we also need to think about the voices of those people whose stories we are collecting. And even if right now the law is pretty much as I presented it to you, that there are some things you can do under the acceptance to copyright, a lot of things that you need to do with permission, it should still also be important that we continue to collect this material and at the very least preserve it and take a risk-managed approach with regards to how we might subsequently make it available in the future. So, a summary slide for you. Collecting digital stories and rights and privacy issues is complicated, which is why I wanted to break this down into key sections to help you through your journey. And it is about understanding who we are, what we're doing, what we're collecting, why we're collecting it. It's about trying to get the right balance between our very roles as cultural heritage organisations and what we do, and making sure that we don't self-censor the very history that we're trying to collect. It's a bit like the tail of rights and privacy issues wagging the dog of our collections. We've got to be aware of them, we've got to be aware of our requirements and do what we can to clear those rights, and do what we can to understand when exceptions to copyright apply, do what we can to safeguard the rights issues in works created by contractors and volunteers, and understand what the funding agreements are. But at the same time, we also need to be aware that we have to balance our compliance issues with pragmatism and proportionality, so that we do continue to collect these stories. And it might be that some digital stories that we're thinking about collecting, perhaps we only make them available on site until such a point when we're comfortable to make them more accessible, either because suddenly we find the rights holder or suddenly the legislation changes to enable the perhaps further access to this material under the exceptions to copyright. But ultimately, it is about risk management. It's about trying to balance all these things together. And as I said, too much risk aversion means that we don't collect the things we should collect. Too cavalier approach means that we leave ourselves open to legal risks that we don't need to encounter. But that sort of safe spot in the middle, that sort of getting the right balance between all these things, enables us to make the right decisions. And actually, the right decisions sometimes might be the right decisions for now, rather than thinking perhaps about it forever. So there's more you can find out about this topic. You've got all the guides that we've given you. We've given you links to the Intellectual Property Office website, links to our own website. We're always publishing stories as well to help you. I want to say thank you very much to my colleagues at Nemicon Associates, but also my colleagues at the Heritage Alliance Media Trust and Charity Digital, particularly Media Trust, for putting on today's event. So I hope that today's been useful. Giving you a template and some considerations, but also perhaps giving you some words of reassurance as well. So I'm very happy to take some questions.
Hello, Naomi. Didn't mean to sort of pop in to.
That's great, Carmen. Hi, Carmen.
Hi. Just for everyone here, I'm the project manager of Heritage Digital, and I have worked in heritage for a while in collections and oral history. So I really wanted to take the Q&A today. Selfishly, I also have some questions, but we've got a load of meaty questions for Naomi over the next 15 minutes. What I will say, just to grab a little bit of airtime, is you really helped me think through some of the past work I've done in oral history, and in particular, a sudden ping of memory story that an oral history from a few years ago of a woman based in Cornwall who sang me a full rendition of a Cornish folk song called Little Eyes, if anyone knows it, which
Nice.
I won't sing, because it actually comes from a 1940s American blues song. It was adapted by Cornish mining workers. So it's making me think that there are rights within the rights that we had, right?
That's right. That's exactly right. And I think we forget that. We think that digital stories are just one person talking, or actually they're not. Digital story can be formed through lots of different ways. Digital stories are photographs, but also it can be people telling other people's stories themselves, or reading from a J.K. Rowling book, right? That could be a digital story, because actually the digital story is the story of Harry Potter, but it could also be someone's commentary about what they were thinking about Harry Potter. So we've got all these layers of rights, and there's so much to unpick and untangle. This is a presentation of ours, and I've tried to kind of like bring it back into frame, but thank you for sharing that, Carmen. That's a really good example.
Right, well, we've got a good amount of questions here, so I will dive in and let's start with the first that came up. So anonymous attendee asks, is there a standard template for assignment of copyright for digital use?
Well, great question. Thank you much. Yes, there is. We've got one on our website. So if you go to naomicorn.com/resources, and also you can jump on the Heritage Digital website as well. I think we've put one up there as well. You can download that template. It's not legal advice. You need it checked if you want that legal advice, but it's a really good standard way of getting a transfer of copyright or a license. Thanks for the question.
Brilliant. Okay, so a good one. Lorraine asks, in a previous session with Naomi Corn, it was stated that the Berne Agreement means that copyright is standard internationally. To what extent do exceptions to copyright vary globally? Thank you.
Thanks, Lorraine. I think that perhaps the standard bit maybe was not quite how I had articulated, because actually what the Berne Convention has are certain copyright principles that are embedded in pretty much every country in the world. So you've got those key principles: copyright's automatic, it needs to last for at least lifetime plus 50 years, although many countries have subsequently extended that, etc. The problem is that the detail is different. Okay, so actually it's the opposite. Copyright laws vary from country to country. And in fact, one of the biggest differences across different jurisdictions are the exceptions to copyright. So effectively what you can do in one country under the exceptions to copyright, you can't necessarily do in another, which is why putting content online under an exception to copyright is deeply problematic, because whilst your country may benefit from those exceptions to copyright, other people in other countries who gain access to the content may not be subject to the same exceptions. Now, the one that perhaps is most useful with regards to that is the quotation exception, because from a sort of very broad brushed analysis of most countries' exceptions to copyright, most countries will have something like a quotation exception, like an extract, being able to use an extract of copyright work, which is why there is a move in the UK to particularly by Professor Tanya Alpin from King's College, who's much more about trying to push the use of the quotation exception. So hopefully, Lorraine, that clarifies that position, but thank you very much for the question.
Okay, I'm going to flip to something that's more around social media and kind of online collecting of quotes. So Maeve asks, I know it's best practice to ask permission to use quotes, but if in a hurry, can I use quotes from our social media or email feedback as anonymous quotes or first names only?
What do you mean? I think, Maeve, thank you very much indeed. I think is what do you mean by using quotes? So a quote from social media could be the whole social media post. So there's been case law in the UK where even the heading of a newspaper could be seen as a whole copyright work. So if you're using the whole of someone's Twitter commentary, that's not actually a quote from it, that's using the whole thing. And I would again go back to stressing, if you're wanting to use content from social media, you must check the terms and conditions of the social media platform upon which you found it. And it might be that you have not just that to comply with, but there may be third-party content in that tweet, for example, a photograph, an illustration, and that you might need to seek permission for separately as well.
So just to sort of imagine into what Maeve might be talking about and thinking about this event today, were I to see a quote from somebody on Twitter that said, "This is the best event I've ever been to in the heritage sector, having a lovely day," and I were to take, "This is the best event I've ever been to in the heritage sector," and use it in my reporting to our funders, what would I need to consider there?
Okay, so I would say the first and foremost, you go to Twitter's terms and conditions and you see how you're enabled to use that quote or that tweet, number one. Second of all, I would suggest that you look at Twitter's terms and conditions to see if you can use it in that way, how you should be presenting it. From Twitter's perspective, I know that they, a bit like Andrew did, if you're wanting to reproduce a tweet, you can't extract the tweet from the platform. So you can't extract the tweet from the interface, the Twitter interface. You have to have that whole thing showing. So those are the things that I would look at, and then I would look at if that person has made that comment, if they just popped a kind of like an image in it, and perhaps they haven't cleared rights in that image, you yourselves could have problems with then reusing that image. And there is an increasing amount at the moment of organizations representing rights holders who are scouring the internet and checking back with those organizations, perhaps who have used images on a digital platform, and getting them to retrospectively pay license fees. There's a huge increase right now in that. So I think the risk is that if you don't do that, you could end up having to pay something that you shouldn't be paid. You shouldn't have had to have paid for.
Brilliant, thank you. Now I'm going to move to one from Paola that is super relevant. How do you report exceptions for posterity? If, say, years down the line, someone questions it and you're no longer in post?
Yeah, this is about documentation. So if you've got a collections, it's a great question, thank you. If you've got a collections management system or a digital asset management system, thinking about how you can create a long-term documented record of how you're using works and the justification of doing that. And that's actually, if you look across at the sort of the body of copyright in terms of fear factors, data protection, we're having to get really good at documenting why we're making decisions, data protection decisions. So that whole bigger picture, bigger part of documentation becomes fundamental. Spreadsheet would be fine, but held on a central drive. Okay, so again, it's not just about information management, documentation. This is about knowledge management as organizations making big decisions about how we're using works and under what terms, even specifics about licenses, durations of licenses, costs of licenses, when licenses expire, the coverage of licenses, all that information with regards to your digital stores, and in fact, use of your collections and other content should be documented.
This is making me think, this and the previous question is reminding me about a case study on the Naomi Corn website by Dr. Ellie Pridgeon about an example of collecting digitally and across social media for a project. So I will drop the link in the chat for that after this. It's really worth reading. Okay, so the next question, particularly relevant to our times of creating webinars, presenting talks online, that's the main way over the last year people have been able to interact with heritage. If you're from Caroline, she says, if you're using a copyright work in a presentation for an evening or educational talk under the quotation or illustration for instruction purposes exception, do you still need to acknowledge that in any way?
You could do. You don't have to, but you could do. I know, taking it back to sort of a cultural heritage perspective, I know when we were giving some support to the IWM, who was producing an interactive on the war in Syria, we were able to justify their use of pieces of content under the quotation exception, and we put that on the exhibition panel that we could use that exception to copyright. So you can do that. I think it was about transparency. You don't have to, but again, it goes back, I think, to the previous question about documenting internally decisions like that you're making. What you absolutely must do is credit. All of the exceptions will require you to credit. And I would also say that you might also want to provide a link to the original source as well.
Brilliant. Okay, we've got time for a couple more questions, so I'll whiz through to Carly, who says, "Hi Naomi, what a great session." When you are asking various volunteers to create assets for a specific project, which will be shared on social media later, what processes can you put in place to ensure you retain rights over those resulting assets?
So so just to clarify, these assets are themselves created by volunteers?
Being created by volunteers.
Okay, so this is about having copyright built into the way in which you deal with volunteers. You can ask them for either a deed of copyright assignment at the point in which you induct them into working with your organisation or volunteering with your organisation, or you can ask for a licence from them. If you haven't done that already, you can do it retrospectively, but you have to have that agreement from them in writing. Building it into the volunteers handbook as well, and also explaining to them what it means. There has been, I think, in the fairly recent past, pushback, I think, from volunteers who felt that some heritage organisations were not as clear and transparent about the copyright status. And so telling them what that means, and at the same time also thinking about how you might credit them, because when you're dealing with volunteers, it's not the same as dealing with staff. And I think that if you are certainly asking for a transfer or assignment of copyright, using a deed of copyright assignment, trying to get a sort of recognition that they've given something to you and therefore you give something back to them with regards to credit, I think creates more of a fair and open relationship between you. The toolkit that we've created for the Heritage Digital Project on volunteers does include guidance and also a template deed of copyright assignment that could be used by your organisations. So I hope that helps.
It sounds like it does, and the link for that was in the chat, but if you need it, head to the Heritage Digital website and you can look under the stream rights and you'll find it. So I'm going to take one last question because I think this question will take us up to time. It's from Jenny, and they say, Naomi, I'm aware that there are some copyright exceptions, for example, say related to the age of the piece. So in some cases, documents may be able to be used after 70 years, for example. But is there anything like this which currently applies to online and digital pieces and the length of the copyright?
So the exception to copyright, I think that you're referring to is where an item was created more than 70 years ago, but you don't know who created it. That's really, I think, the exception. The examples that come to mind are, say, photographs taken during the Second World War, where we just don't know who the author is. And that's after we've tried to find who the author is. And there is, of course, an overlap between anonymous works, which these are, and orphan works. That isn't really transferable to digital media, of course, because of the age of digital media being subsequently younger. And also, copyright laws are incredibly reactive. So even the changes that we had in 2014 in the UK, which were, I mean, they transformed our copyright legislation, particularly for cultural heritage organisations, were 15 years in the making. They took 15 years to become law in the UK. And so the way that copyright law works is so slow to respond that I don't imagine anytime soon we'll have anything that's the same that could refer to digital stories. So it really becomes, I think, going through that blueprint that I provided for you, which is looking at who created it, can you get permission from them, looking at the terms of the platform upon which you find it, and then thinking about, ultimately, if none of those apply, then thinking about risk management and how far can we collect things, and risk management might mean that we collect it but we don't use it, or maybe risk management might mean that we collect it and we use it only for certain purposes, or risk management might mean that we collect it, we use it, and we take a massive breadth of risk and use it perhaps more publicly, but that is a risk, right? It doesn't, we can take a big gulp of risk, but that still means there'll be consequence. And so I think that's really where we're at right now. It doesn't mean things won't change, but I think if I'm lucky, it'll be in my lifetime.
Brilliant. And it reminded me, I've been reading the articles on the Naomi Corn Associates website recently, but there's an interesting article about NFTs, for example. So the medium is changing, but the rights aren't. And yeah, also recommend reading that.
That's it. And I do think, again, as I said, really just to summarize, this is a complex issue. Any of you that have been joining us for this year-long project, or the webinars that we've been doing, or the publications that we've been generating, you can see that. And I would say that digital stories is perhaps the most complicated because it brings in all these issues together. But ultimately, we've got to remember who we are and what we're doing. And if we are too risk averse, the impact of those decisions downstream is going to be absolutely disastrous, because we are the people that collect this stuff. So even if we're collecting it and we don't do anything with it, that's okay. And then we can start looking at other options in terms of how we subsequently can use it and for what.
Brilliant. Well, thank you so much, Naomi. That is all that remains for me to say. That's all we've got time for in this session, but yeah, it's a huge topic and we have resources. Naomi Corn Associate has resources. You can read on more.
Thank you so much.
So I'm going to take us now to the break. We've got a longer break coming up. It is going to be around 30 minutes. We're responding to the feedback we've had on previous events where people really wanted to step away and have a coffee or think about what they were learning. So please do that, or you can join some of us over in a networking breakout room where we've got a couple of questions. I'm not sure if any of them are as exciting or ponderous as Andrew's. Who would you let take over your social media? Whose voice would you have? But I'll be heading over there after getting a coffee. Step away from your screen. If you're on Twitter, let us know what you're thinking, what you've learned today. And we'll be back here at around midday for a panel on how technology can be used to shed light on your digital stories and kind of boost them to more audiences. So hope to see you in a little while. Thank you.
Thanks, everyone. Thanks.